Good evening. We welcome you at the entrance, and today we are going to discuss about the topic writs. Before we start, please like and subscribe to our channel to get more interesting videos. To start with, what is writ? A writ means an order, that is anything that is issued under an authority is known as writ. The Constitution of India empowers the Supreme Court and the High Court to issue writs for the enforcement of the fundamental rights conferred by Part 3 of the Indian Constitution. And the articles that protect them are Article 32 and Article 226. Basically, there are 5 types of writs. First, Habeas Corpus. Second, Mandamus. Third, Certiorari. Fourth, Prohibition. And fifth, QUO-WARRANTO. Summarizing the key points, they are: first, a writ is a formal legal document that orders a person or entity to perform or to cease performing a specific action or deed. Writs are drafted by courts or other entities with jurisdictional or legal power. Third, warrants and subpoenas are the two common types of writs. Discussing about habeas corpus now. First, habeas corpus. Habeas corpus means you should have the body. The writ is issued to produce a person before a court who has been detained or imprisoned, and he has not been produced before the magistrate within 24 hours, whether in prison or in private custody, and would release that person if such detention is found to be illegal. The purpose of the writ is not to punish the wrongdoer but merely to release the person unlawfully detained. However, under Article 21, that is protection of life and personal liberty, it cannot be suspended even during the proclamation of emergency. Therefore, habeas corpus becomes a very valuable writ for safeguarding the personal liberty of an individual. While the Supreme Court can issue the writ of habeas corpus only against the state in case of violation of fundamental rights, whereas the High Court can issue it also against private individuals illegally or arbitrarily detaining any other person. तो हम क्या समराइज करते हैं? हेबियस कॉर्पस का मतलब है किसी भी इंसान को जिसको गलत तरीके से हिरासत में लिया गया है और मजिस्ट्रेट के सामने 24 घंटे के अंदर अंदर नहीं पेश किया गया है, उसको कोर्ट के सामने लाना होगा, और अगर कोर्ट को सही लगता है तो उस पर्सन को वो रिलीज़ कर सकती है अगर कोर्ट को ऐसा लगता है कि उन्हें इल्लीगली या गलत तरीके से डिटेन किया गया है. फैक्ट्स अबाउट हेबियस कॉर्पस इन इंडिया. सुप्रीम कोर्ट और हाई कोर्ट कैन इशू दिस रिट against both private and public authorities. Habeas corpus cannot be issued in the following cases. What are the cases? First, when the detention is lawful. Second, when the proceeding is for competent of a legislature or a court. Third, detention is by a competent court. And fourth, detention is outside the jurisdiction of the court. The next writ is mandamus. Mandamus is a term which means to command. It is a judicial remedy in the form of an order to act legally and to abstain from perpetrating an unlawful act. The Supreme Court may issue a mandamus to enforce the fundamental rights of a person when its violation by some governmental order or act is alleged. The High Courts may issue this writ to direct an officer to exercise his constitutional and legal powers, to compel any person to discharge duties cast on him by the Constitution or the statute, to compel a judicial authority to exercise its jurisdiction, and to order the government not to enforce any unconstitutional law. For example, where A has a legal right which casts certain legal obligation on B, A can seek a writ of mandamus directing B to perform its legal duty. This writ of command is issued by the Supreme Court or the High Court when any government, court, corporation, tribunal, or public authority has to perform a public or a statutory duty, but they fail to do so. Now, two important cases related to the writ. The first is Unni Krishnan versus Union of India. In Unni Krishnan versus Union of India, it was held that a private medical engineering college comes within the writ jurisdiction of the court irrespective of the question of aid and affiliation. Second, Jatinder Kumar versus State of Punjab. In this, it was held that Article 320, subsection 3 of the Constitution, which provided that before a government servant was dismissed, the UPSC should be consulted. They did not confer any rights on a public servant, and hence the failure to consult the Public Service Commission did not entitle the public servant to get mandamus for compelling the government to consult the commission. However, if the authority is under law obliged to exercise a dissection, mandamus would lie to exercise it one way or the other. अब हम देख लेते हैं फैक्ट्स अबाउट मैंडामस इन इंडिया. जैसे कि हेबियस कॉर्पस होता है, मैंडामस जो है किसी प्राइवेट इंडिविजुअल के अगेंस्ट नहीं इशू हो सकता है. मैंडामस किन किन केसेस में नहीं इशू हो सकता है वो है, पहला, to enforce departmental instruction that does not possess statutory force. Second, to enforce a contractual obligation. Third, to order someone to work when the kind of work is discretionary and not mandatory. Fourth, mandamus can't be issued against Indian president or state governors. Or last, against the Chief Justice of a high court or any other court in a judicial capacity. उनके अगेंस्ट भी मैंडामस नहीं इशू हो सकता है. अगला रिट है हमारा सर्शररी. Certiorari is a term which means to inform. Certiorari may be defined as a judicial order operating in persona and carried out in the original legal proceedings. Be issued against constitutional bodies, statutory bodies like corporation, non-statutory bodies like companies, and cooperative societies and private bodies, and person requiring the records of any action to be certified by the courts and dealt with according to the law. अब हम क्या देखेंगे कि ऐसे कौन से ग्राउंड्स हैं जिनके बेसिस पर रिट ऑफ सर्शियरी इशू हो सकता है. पहला, जहाँ लैक ऑफ ज्यूरिसडिक्शन है. दूसरा, जहाँ एक्सेस ऑफ ज्यूरिसडिक्शन है. तीसरा, जहाँ अब्यूज ऑफ ज्यूरिसडिक्शन है. चौथा, वायलेशन ऑफ द प्रिंसिपल्स ऑफ नेचुरल जस्टिस. और पांचवा, एरर ऑफ लॉ एपरेंट ऑन द फेस ऑफ द रिकॉर्ड. इसके ऊपर केस है जिसका नाम है सैयद याकूब वर्सेस राधा कृष्णन. इसमें क्या हुआ था? इट वॉज हेल्ड दैट द jurisdiction of the High Court to issue a writ of certiorari is a supervisory jurisdiction, and the court exercise it is not entitled to act as an appellate court. An error of law which is apparent on the face of the record can be corrected by a writ, not an error of fact. However, if a finding of fact is based on no evidence, that would be regarded as an error of law which can be corrected by certiorari. We will see the facts about certiorari in India. इसके 3 stages हैं. पहला, pre-1991. In pre-1991, the writ of certiorari used to be issued only against judicial and quasi-judicial authorities and not against administrative authorities. Second, post-1991. In this, Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting the rights of individuals. And third, it cannot be issued against legislative bodies and private individuals or bodies. अगला रिट है हमारा prohibition. Prohibition refers to forbid or to stop and is popularly known as stay order. इसमें क्या होता है बेसिकली कि कोई भी सुप्रीम कोर्ट या कोई भी हाई कोर्ट हमारे कंट्री का जब ये देखता है कि कोई लोअर कोर्ट या कोई क्वाजी जुडिशियल बॉडी उन्होंने अपने पावर्स को वायलेट किया है, तो वो अपर कोर्ट जो है वो प्रोहिबिट कर सकता है लोअर कोर्ट को टू कंटिन्यू द प्रोसीडिंग्स इन अ पर्टिकुलर केस. दैट इज, the writ is issued by the Supreme Court or any high court when a lower court or quasi-judicial body tries to violate the powers vested in it, prohibiting the latter from continuing the proceedings in a particular case. In India, prohibition is issued to protect the individual from arbitrary administrative actions. Prohibition does not lie against an authority discharging executive functions, but against an authority discharging judicial functions. अब हम देख लेते हैं फैक्ट्स अबाउट प्रोहिबिशन इन इंडिया. क्या है? पहला, रिट ऑफ प्रोहिबिशन कैन ओनली बी इशूड अगेंस्ट जुडिशियल एंड क्वाजी जुडिशियल अथॉरिटीज. सेकेंड, इट कांट बी इशूड अगेंस्ट एडमिनिस्ट्रेटिव अथॉरिटीज, लेजिस्लेटिव बॉडीज एंड प्राइवेट इंडिविजुअल्स और बॉडीज. अब हम देखेंगे डिफरेंस बिटवीन प्रोहिबिशन एंड सर्शियरी. पहला, while the writ of prohibition is available during the pendency of proceeding, writ of certiorari can be resorted to only after the decision has been pronounced or announced. Second, both the writs are issued against legal bodies. आखिरी writ है हमारा QUO-WARRANTO. QUO-WARRANTO is a term which means by what warrant. इसका मतलब, the writ is issued to restrain a person from holding a public office to which he is not entitled. क्या मतलब? कि ये रिट इशू होता है उन लोगों के लिए, उन लोगों को रोकने के लिए टू होल्ड देयर पोजीशन इन पब्लिक ऑफिस जिसके लिए वो एंटाइटल्ड ही नहीं है. इट कैन बी इशूड अगेंस्ट ऑफिसेस क्रिएटेड बाय द कॉन्स्टिट्यूशन such as Advocate General, Speaker of Legislative Assembly, officers under Municipal Act, members of Local Government Board, university officials and teachers, but it will not issue against the managing committee of a private school which is not appointed under the authority of the state. इसका मतलब ये है कि स्टेट के अंडर जो भी पब्लिक अथॉरिटी आती हैं और अगर वहाँ पर किसी इंसान ने गलत तरीके से ऑफिस होल्ड किया हुआ है जिसके लिए वो एंटाइटल्ड नहीं है, देन थ्रू द रिट ऑफ QUO-WARRANTO दैट पर्सन कैन बी रिमूव्ड. अब है फैक्ट्स अबाउट QUO-WARRANTO इन इंडिया. पहला, QUO-WARRANTO can be issued only when the substantive public office of a permanent character created by a statute or by the constitution is involved. Second, it can't be issued against private or ministerial office. अब हम देखेंगे conditions for the issue of QUO-WARRANTO. पहला condition, the office must be public and it must be created by a statute or by the constitution itself. Second, the office must be a substantive one and not merely the function or employment of a servant at the will and during the pleasure of another. तीसरा, there must have been a contravention of the constitution or a statute or statutory instrument in appointing such person to that office. अब हम देखेंगे कि रिट कैसे डिफर करता है सुप्रीम कोर्ट में और हाई कोर्ट में 3 पॉइंट्स के अंदर. पहला पॉइंट हमारा पर्पस, दूसरा टेरिटोरियल जुरिस्डिक्शन एंड तीसरा पावर. तो पर्पस के अकॉर्डिंग सुप्रीम कोर्ट कैन ओनली एनफोर्स फंडामेंटल राइट्स एंड हाई कोर्ट कैन एनफोर्स फंडामेंटल राइट्स बट ऑल्सो फॉर द पर्पस the expression, that is for any other purpose, refers to the enforcement of even an ordinary legal right. Second, territorial jurisdiction, that is Supreme Court के अंदर against a person or government throughout the territory of India, and High Court के अंदर against a person, residing government or authority located within its territorial jurisdiction only or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. तीसरा पॉइंट ये है पावर. तो सुप्रीम कोर्ट का आर्टिकल 32 is a fundamental right. Supreme Court may not refuse to exercise its power to issue the writs. और हाई कोर्ट के अंडर it is discretionary, may refuse to exercise its power to issue writs. So friends, this was all about writs. I hope I was able to convey and clear your concept based on writs. If you found this video interesting, please like, share and subscribe. Also, subscribe to our channel for more upcoming interesting videos. If you have any comments, please post it in the comment box. Thank you.